everyone, I'm Aratrika Bhomik and I welcome you all to the second episode of the much-awaited LiveLaw's exclusive series titled 100 Important Supreme Court Judgments of the Year 2022. If you haven't watched the first episode of this series, you can view it by accessing the link given in the description box below. You can also access the judgments we have covered by clicking on the links given in the description box below. So without further ado, let's dive right into it. In the case titled S.K. Naushad Rahman and others versus Union of India, the Supreme Court discussed the concept of right to family life and observed that the state's transfer policy must give due consideration to the importance of protecting family life. The state's interference in the rights of privacy, dignity, and family life of persons must be proportional. The bench of Justices D.Y. Chandrachud and Vikram Nath observed while asking the Union government to revisit its transfer policy for the tax department. Upholding the minimum age requirement of 35 years for applying for the Delhi Higher Judicial Services examination, the Supreme Court in the case titled High Court of Delhi versus Devina Sharma held that the prescription of a minimum age limit for the selection of district judges is not contrary to the Constitution. A bench of Justices D.Y. Chandrachud, A.S. Bopanna and Hima Kohli held that Article 233 Clause 2 of the Constitution only prescribes a minimum eligibility that an advocate should have at least 7 years practice for selection as a district judge, and that this does not preclude the stipulation of a minimum age requirement. The Supreme Court in the case titled Indian Ex-Servicemen Movement versus Union of India upheld the manner in which the central government introduced the one rank, one pension scheme in defense forces as per its notification dated November 7, 2015. The bench of Justices D.Y. Chandrachud, Surya Kant and Vikram Nath refused to accept the challenge made by the association Indian Ex-Service Movement against the 2015 notification issued by the centre. In a judgment having wide ramifications in the insurance law sector, a bench comprising Justices Hemant Gupta and V. Ramasubramaniam in the case titled the Oriental Insurance Company Limited versus Sanjesh held that a condition in the insurance policy which bars the filing of the claim after the specified time period is contrary to Section 28 of the Indian Contract Act of 1872 and is thus void. A bench comprising Justices L.N. Rao and B.R. Gavai in the case titled Pattali Makkal Karchi versus A. Mayur Perumal held that the 2021 Tamil Nadu Act that provided 10.5% reservation in education institutions and government jobs for the Vaniyar community out of the 20% reservation available to the most backward classes to be unconstitutional. A bench comprising Justices A.M. Khanvilkar, Dinesh Maheshwari and C.T. Ravikumar in the case titled Noel Harper versus Union of India upheld the 2020 amendments made to the Foreign Contribution Regulation Act of 2010, which introduced restrictions in the handling of foreign contributions by organizations in India. While the petitioners challenged the amendments as arbitrary and stringent, making the functioning of NGOs extremely difficult, the centre said that the changes in the law were necessary to prevent malpractices and diversion of funds by the NGOs. A significant verdict given by a bench comprising Justices Ajay Rastogi and A.S. Oka in the case titled Maniben Manganbhai Bhedia versus District Development Officer and others extended the protection of the Payment of Gratuity Act to Anganwadi workers. The court held that Anganwadi workers are doing a full-time job and are performing statutory functions under the National Food Security Act and the Right to Education Act. The judgment also discussed the sufferings of Anganwadi workers as they are paid a paltry remuneration in return of their valuable services for ensuring education and nutrition of young children. The Supreme Court in the case titled Bar Council of India versus Twinkle Rahul Mangonkar and others open the doors for persons doing other jobs to practice as advocates by accepting a suggestion made by the amicus curiae that persons engaged in other employments can be permitted to provisionally enroll with the concerned Bar Council and to appear in the All India Bar Examination, that is the AIB, and that upon clearing the examination they can be given a period of 6 months to decide whether to join the legal profession or to continue with the other job. The order, passed by a bench comprising Justices Sanjay Kishan Kaul and M.M. Sundaresh, is also significant for its discussion on reforms needed for legal education and the AIBE. Observing that a public employer cannot be asked to carry out a mass absorption of over 11,000 workers without a recruitment process, the Supreme Court in the case titled Ranbir Singh versus S.K. Roy, Chairman, Life Insurance Corporation and another, decided a 4-decade-old dispute related to the regularization of part-time workers in the Life Insurance Corporation. Allowing for backdoor entries into service is an anathema to public service. A bench comprising Justices D.Y. Chandrachud, Surya Kant and Vikram Nath observed, and I quote here, LIC as a statutory corporation is bound by the mandate of Articles 14 and 16 of the Constitution. As a public employer, the recruitment process of the corporation must meet the constitutional standard of a fair and open process. Allowing for backdoor entries into service is an anathema to public service. Taking into account the plight of Indian medical students who could not complete the clinical training of their foreign MBBS course due to the COVID-19 pandemic, the Supreme Court in the case titled National Medical Commission versus Pooja Thandu Naresh has issued certain important directions to the National Medical Commission. A Supreme Court bench comprising Justices Hemant Gupta and V. Ramasubramanian decided that the NMC must frame a scheme as to a one-time measure within 2 months to allow students who have not actually completed clinical training to undergo clinical training in India in the medical colleges, which may be identified by the Commission for a limited duration as may be specified by it on such charges which it determines. Related to this is another decision called Aravind R.A. versus Secretary to Government of India, Ministry of Health and Family Welfare, where the Supreme Court upheld the NMC regulations prescribing additional test qualifications for foreign medical graduates. The Supreme Court in the case titled Jacob Pulial versus Union of India held that no individual can be forced to get vaccinated and that the right to bodily integrity of a person under Article 21 of the Constitution includes the right to refuse vaccination. A bench comprising Justices L.N. Rao and B.R. Gavai also held that the vaccine mandates imposed by various state governments and other authorities in the context of the COVID-19 pandemic are not proportionate. The court held that as there is no substantial data to record and show that the risk of transmission of the virus from unvaccinated persons are higher than from vaccinated persons, it upheld the emergency authorization given by the Union government for COVID vaccines such as Covishield and Covaxin, and also the approval for vaccines for children. The court further issued directions for publication of clinical trial data and adverse events following immunization. In a significant judgment having wide-ranging impact on several pending tax cases across the country, the Supreme Court in the case titled Union of India versus Ashish Agarwal saved several reassessment notices issued by the Income Tax Department by not following the new procedure introduced after the Finance Act of 2021 by deeming them as notices under Section 148A. A bench comprising Justices M.R. Shah and B.V. Nagaratna issued these directions, having pan-India effect to strike a balance between the interests of the revenue and the assessees. In relation to the criteria for senior advocate designation, the Supreme Court in the case titled Indira Jaising versus Supreme Court of India clarified that the High Courts should allocate 1 mark each for each year of practice from 10 to 20 years instead of allocating 10 marks flat for the counsel who has put in 10 to 20 years of practice. a bench comprising Justices U.U. Lalit, S. Ravindra Bhatt and P.S. Narasimha issued this clarification while allowing a prayer in an application made by senior advocate Indira Jaisingh. The Supreme Court in the case titled Nedumpilli Finance Company Limited versus State of Kerala held that state enactments such as the Kerala Moneylenders Act of 1958 and the Gujarat Moneylenders Act of 2011 will have no application to non-banking financial companies regulated by the Reserve Bank of India. The Supreme Court bench comprising Justices Hemant Gupta and V. Ramasubramaniam observed that Chapter 3B of the RBI Act is a complete code in itself and that the power of intervention available for the RBI over such NBFCs is from the cradle to the grave. In a historic development, the Supreme Court of India in the case titled S.G. Bombatkeri versus Union of India ordered that the 152-year-old sedition law under Section 124A of the Indian Penal Code should be effectively kept in abeyance till the Union government reconsiders this provision. In an interim order, the Supreme Court urged the centre and the state governments to refrain from registering any FIRs under this provision while it was under reconsideration. A Supreme Court bench comprising Chief Justice of India N.V. Ramana, Justice Surya Kant and Justice Hema Kohli held that all pending trials, appeals and proceedings with respect to charges framed under Section 124A of the IPC be kept in abeyance. A Supreme Court bench comprising Justices M.R. Shah and B.V. Nagaratna delivered a significant verdict in the case of Prabha Taigi versus Kamlesh Devi, settling several questions related to the Protection of Women from Domestic Violence Act of 2005. It was held that a victim of domestic violence can reinforce her right to reside in a shared household irrespective of whether she actually lived in the shared household. The court further held that every woman in a domestic relationship has a right to reside in the shared household even in the absence of any act of domestic violence. Overruling some of its earlier judgments, the Supreme Court in the case of Surendran versus State of Kerala observed that the evidence of a deceased wife under Section 32 of the Evidence Act with respect to cruelty could be admissible in a trial for a charge under Section 498A of the IPC. In the Bilkis Bano case titled Radhesham Bhagwanwan Das versus State of Gujarat, the Supreme Court held that the Gujarat government had the jurisdiction to decide the remission of convicts even if the trial was held in the state of Maharashtra. A bench comprising Justices Ajay Rastogi and Vikram Nath held so while allowing writ petition filed by one of the convicts. Recently, the bench dismissed an application filed by Bilkis Bano seeking a review of the judgment. Exercising the powers under Article 142, a bench comprising Justices L. Nageshwar Rao and B.R. Gavai ordered the release of A.G. Perarivalam in the case titled A.G. Perarivalan vs. State through Superintendent of Police, Chennai, Tamil Nadu, who was significantly serving a life sentence in the Rajiv Gandhi assassination case, considering the fact that he was undergoing sentence for 32 years and that the Tamil Nadu government had recommended his remission in the year 2018, which the governor had kept pending for over 4 years. The judgment also reiterated the important principle that the governor is bound by the advice given by the state government regarding the remission. Also, with respect to the offence under Section 302 of the IPC, the court held that the state government is the appropriate government to decide the remission instead of the union government. Few months later, the court ordered the release of the remaining convicts in the case as well, following the Perarivalan precedents. In the case titled Madhya Pradesh High Court Advocates Bar Association versus Union of India, the Supreme Court of India upheld the constitutionality of Section 3 of the National Green Tribunal Act of 2010, which provides for the establishment of the entity by the central government. The Supreme Court held that the National Green Tribunal under Sections 14 and 22 of the NGT Act does not oust the High Court's jurisdiction under Articles 226 and 227, as the same is part of the basic structure of the Constitution. The bench of Justices K.M. Joseph and Rishikesh Roy also held that the remedy of a direct appeal to the Supreme Court under Section 22 of the NG Act is not violative of the Constitution of India. Thank you. We will shortly come back with the last 3 episodes of this series. Stay tuned to LiveLaw for more such updates.